In DENTONS UK and Middle East LLP versus Solicitors Regulation Authority Limited, Lord Justice Bean, Lord Justice Jeremy Baker and Lord Justice Zaccaroli determined the costs of a successful appeal by the solicitors firm DENTONS against disciplinary findings originally made by the Solicitors Disciplinary Tribunal and upheld by Lang J in the High Court. The Court of Appeal had allowed Denton's appeal in its substantive judgment of the 27th of April 2026, quashing the tribunal's decision and remitting the matter on a different legal test. The principal costs issue was whether the SRA's status as a regulatory body shielded it from an adverse costs order on appeal, as it contended by relying on Baxendale-Walker versus Law Society. The SRA argued that the principle disapplying the ordinary costs follow the event rule in tribunal proceedings extended equally to appellate proceedings, citing observations of Lord Phillips in an earlier Baxendale-Walker versus Law Society decision. The court rejected that argument, holding itself bound by Wingate versus Solicitors Regulation Authority, in which the Court of Appeal had expressly confirmed that parties appealing from the tribunal enter the costs-shifting regime under Rule 44.2 on equal footing. The Wingate decision was not rendered per incuriam by the absence of citation to the second Baxendale-Walker decision, whose relevant passage was, in any event, obiter. The court ordered the SRA to pay 65% of Denton's costs of both appeals, subject to detailed assessment, and ordered a payment on account of £200,000 within 21 days, applying a substantial discount from the figure of £515,891, representing 65% of Denton's total costs of £793,679. Quote, "We do not agree. The Court of Appeal's decision in Wingate, which expressly considered whether the approach in Baxendale-Walker should be applied on appeal, is binding on us. In our judgment, the Court of Appeal in Wingate was, in any event, correct in determining that the reasoning which underpinned the Court of Appeal's decision in Baxendale-Walker does not extend to appeals from the SDT. The approach applied in the SDT is based on the fact that the SRA's regulatory responsibilities require it to bring properly justified complaints to the SDT's attention, without fear of the chilling effect of an adverse costs order. The same does not apply, however, where, as here, the SRA has the benefit of a determination by the SDT and then challenges it on appeal. In that context, its position is, in our judgment, more akin to that of a normal litigant.
For a detailed summary of this decision, visit tmclegal.co.uk.